Anyway, we had a letter from Tindall Gask Bentley, who is one of South Australia's law firms, and we're going to talk to Senior Associate Julie Height. Julie, thanks for joining us. Tell us the issue here.
John, I guess,
Leon.
Firstly, I must say, Leon, sorry. Firstly, I must congratulate you on the fantastic support that you're giving the consumers on this issue. Consumers are obviously faced with the difficulty of seeing this caveat on their title and not being able to deal with their title thereafter until they withdraw that caveat. My view is that a supplier needs to have some type of security, obviously, for the repayment of their debt. But like you say, a caveat is likely to be disproportionate to the debt they're trying to secure. And perhaps more appropriately, they should be looking to secure that with some type of retention of title over the equipment, and that perhaps being registered on the Personal Property Security Register. But that being said, the consumer is then, the homeowner is then faced with what they do with this caveat. And logistically, the process may seem fairly simple. The homeowner can simply go to the Lands Titles Office and complete a pro forma application to remove the caveat and pay a small fee of $144. There's a reason that that's particularly dangerous. Whilst it's the procedure to be adopted, before that is adopted, the homeowner should really obtain appropriate advice. And that is because once the application's lodged, from the elapse of 21 days, that caveat will automatically come off of the title. So that really forces the caveator, and in this case the suppliers, into a corner to either fight now or forever walk away, essentially. If they're going to fight it, and that is to prove that they have a caveatable interest against the title, they'll need to apply to the Supreme Court or the District Court for an extension of time within which to remove the caveat. And that process alone, the Supreme Court filing fees over $1,000.
Yep.
The legal fees associated with that will be, $5,000 to $10,000, and that's simply
$5,000 to $10,000. So let's say you're average consumer, and you go to the Lands Titles to get it taken off, and then the other company wants to push the envelope. Are you telling me that the danger is you could be up for their costs?
Oh, absolutely. So if the court determined that there was a caveatable interest, and this is beside whether the debt is payable or not, but if there is a caveatable interest, then the risk is, or the general principle is, that the costs will generally follow the event.
Okay, now John Rao has already said that he thinks that the companies that do this are claiming an interest in the land they don't have.
Well, that's really hard for me to comment without seeing the terms or the specific terms of the contract.
Yeah.
And it is a fairly difficult topic to determine whether one has a caveatable interest or not. And certainly there's certain charging clauses that suppliers can have in their terms of engagement, which would be sufficient to create a caveatable interest in one's title.
Okay, now,
and at the end of the day, that's the only question that the court are concerned about. Is there a caveatable interest?
All right. Now, let's say you're presented with a company that offers to do something on a rent purchase plan, and they're not going to use the consumer mortgage system, which you're referring to, and normally most people who supply goods do that, but in this case they're not, or they're adding to it by using caveats. One thing John Rao said, as also Consumer Affairs Minister, was if you don't like that, you can simply cross it out and initial it, and unless they come back and challenge you, it therefore is deleted from the contract.
Well, not necessarily. I mean, that's the usual terms of contract apply in that situation. So if both parties need to consent to that amendment. So if the supplier has already signed or their representatives have already signed and you cross out that, then you're amending the terms after the event. So I think that would be quite difficult. Often these terms and conditions are not negotiable. It's either take this service, these are our terms, otherwise go elsewhere.
All right. So what's your advice to consumers here?
Obviously read the fine print, and I think that I'd seen in previous articles or transcripts that Rao had suggested if you see the word caveat, certainly be aware. But there's other terms that might also alert the consumer, and they include a charge, which effectively will have the same effect, may create a caveatable interest. And if you do, if you are faced with a caveat being lodged against your title, don't simply make an application to remove that. Obtain appropriate advice in the first instance and deal with the issue that supports that. So perhaps, at the end of the day, both parties are really concerned about is the payment of the debt and the payment of the services. So concentrate on that, and as a matter of of course, the caveat will eventually come off when that matter is dealt with. But to simply just make an application without attempting to deal with that issue first backs the supplier or the caveator into a corner. And if they want to protect that, then they'll be making quite an expensive application to the court.
Julie Height, thank you. Julie is Senior Associate with Tindall Gask Bentley.